and the notwithstanding clause is used, the alarm bells go off from everybody, and the entire Canadian punditry class talks about the infringement of rights, the override of rights. But whenever a case comes up where the Section 1 is used to uphold what the court calls an infringement of rights, we never hear any alarm bells, despite the court's own way of talking about this is talking about there having been an infringement of rights. It's just justified. But there's an asymmetrical skepticism where people are not skeptical enough about what happens in courts, and they are extremely skeptical about what happens in legislatures. And I don't think that they're wrong sometimes about the legislatures. I just think we should be applying our skepticism a bit more evenly.
Welcome to Inside Policy Talks, the podcast of the Macdonald-Laurier Institute. I'm Mark Mancini. I'm a senior fellow at MLI and also a law professor at Thompson Rivers University. For nearly 40 years now, one Supreme Court ruling has really loomed large in shaping how conflicts between rights in our charter are determined in Canada. And that case is called the Queen versus Oakes, decided in 1986. Oakes gave us what lawyers call the famous Oakes test, which courts still use today to assess whether limitations on charter rights are justified. The test is widely cited in courts, seems like it's orthodox law in Canada, but critics argue it's become confusing, unpredictable, and importantly, undermines the historic power that legislatures are meant to share in the construction of rights in Canada. That's why we have a new MLI paper that says that the Oakes test is in need of a major renovation. And we're lucky because the authors of that paper, titled Renovating Oakes, Why Section 1 Justifies Reasonable Limits and Not Infringements on Charter Rights, they're here today to make the case. We've got Gerard Kennedy, who's a professor at the University of Alberta Faculty of Law. He's also a lawyer with extensive experience in public law and charter litigation. We also have with us Geoffrey Sigalet, who's a professor of political science at the University of British Columbia at Okanagan. He's also there the director of the UBC Research Group in Constitutional Law. And he studies constitutional interpretation, judicial review, and democratic governance. Together, within their paper, they argue that when it comes to this Oakes test, courts have got it wrong, and they've drifted away from the Charter's original logic. And so today we're lucky we're going to be chatting with Gerard and Jeff. Before we get started, I'd like to just remind you to like and subscribe. Really does help us reach more people with these important ideas, more important today than ever. Gerard and Jeff, welcome to the podcast. It's great to see you both.
Pleasure to be here.
Thanks for having us on, Mark.
Great. Well, let's start with brass tacks where the rubber meets the road. For Canadians who are listening to this, they aren't familiar with what the Oakes test says and what it does. Can you, maybe Jeff, to start with, give us an opinion, an example of a ruling where this test has been applied and where it's had a real impact on the day-to-day lives of ordinary Canadians?
Well, let's think. I think that in terms of, we can just talk about Oakes itself, perhaps. Oakes itself was a case involving an alleged drug dealer who was found with vials of hashish oil on him. And in the case, the question wasn't, one of the questions that came up was, what does the courts make about the limitation of potential limitation of rights based on a statute that had required the Crown to have the onus on it, to have the onus on Mr. Oakes, the alleged drug dealer, to prove that he was not dealing drugs given the amount of drugs he was found with and the paraphernalia in his car and the cash he had on him. And so what the Oakes test did was it set out and made it so that the legal inquiry would be partly about inquiring whether or not it was a justifiable infringement of his right to be presumed innocent. So the court set up the legal question in that case in a way that is very influential on almost all, and becomes influential on almost all charter litigation that involves that kind of fundamental rights question. So insofar as we ask about how it's impacted Canadians, on almost any, if you take any given controversial rights case today, you're probably dealing with a significant part of that case is determined by the framework of how to understand rights, and what courts are doing when they're inquiring about the limitation of rights is using this Oakes test. And so we can talk about the fundamental parts of the Oakes test as we go on. But that's my sense, is that if you hear about a case that's really controversial today, or not even controversial, the Oakes test is probably part of it.
Yeah. So it really does seem, Jeff, from your comments, like, Oakes test has had an outsized influence in Canadian constitutional law, and it remains with us today. So it's worth, talking a little bit about what it is and what it does. So maybe I'll turn to you now, Gerard. Jeff talked about the case that birthed the test, but can you tell us what are the components of this test? And after that, why do you think it's had such a big impact in Canadian constitutional law 40 years on?
Yeah, so the rights guaranteed in the Charter are all subject to reasonable limits pursuant to Section 1 of the Charter. And prior to Oakes, there had clearly been a significant, for want of a better word, ad hocery about how to determine whether or not a particular limit on a Charter right was reasonable. So in the Queen and Oakes, Chief Justice Dixon prescribes a test that is meant to guide the court in this regard. He reminds us all that we start by asking whether the particular right, I believe the word he uses is infringed or violated. So we need to make sure before we even get to Oakes that a right guaranteed by the Charter, in the case of Oakes, it was the right to be presumed innocent, has been infringed, and we're going to come back to that language, by the alleged by the legislation. And so he says, in order to justify a rights limiting law, the government bears the onus of proof. The government must show that a law has a pressing and substantial objective. That's the first stage. There has to, in other words, be a good reason to limit someone's rights. This is almost never controversial, might I add. The government, to its enormous credit, rarely has a illegitimate reason. It has some policy goal, and the question is, has it struck the right balance? In terms of striking the right balance, he says we then have to ask whether there is proportionality between the rights limiting measure and the policy objective that the government is pursuing. This means, one, there needs to be a rational connection between the law and the government's policy objective. That's usually not controversial, but maybe we'll talk about Oakes itself in a bit. Two, the right has to be reasonably minimally impaired. This phrase, minimal impairment, he says in Oakes that it has to be minimally impaired by the law. That language did get backed away from in later years. There's an element of deference to the government at that stage. And lastly, there's an overall balancing of the salutary benefits of the law against its deleterious effects. Why has this had such an impact? Well, because every time a piece of legislation is challenged for being unconstitutional, things are a little bit different when we're talking about executive or administrative or police action. But every time a piece of legislation is challenged for allegedly being unconstitutional, first you ask whether the right is limited, let's just say, and then you ask, is the limit justified? So on the way to determine whether or not the limit can be justified, you have to consider the Oakes test. No case is going to, or no law, piece of legislation, is going to be struck down for offending the Charter unless the Oakes test is addressed, if only sometimes cursorily.
Okay. So, this all sounds great. And so now let's get into what's the big deal here? What's the problem with this? In your paper, one of your big claims is that the Oakes test needs some renovation and it needs some work. Before we get into what your proposed renovations are, what is the big problem with the Oakes test that requires your attention and that has your attention? Why do we need to renovate this test? Maybe we'll go with Jeff.
Yeah, I mean, when you asked me about, sorry, if you asked me earlier about what specific everyday case is affecting everybody's lives, well, one of my views is, that the everyday people don't always experience a charter as much. I try to teach my students that federalism, in some ways, is more of an everyday thing than the charter. But when we get to these big, important cases where the charter really does matter, like questions about really controversial issues, like the right to vote and who gets to vote and when and how. The Oakes test structures the debate insofar as the debate enters the courtroom and we litigate questions about who has the right to vote and when. So the Oakes test has had a significant impact, and in my view, and I believe Gerard shares my view, that there's been problems with the way the court approached the right to vote in some highly controversial cases that were that where the very structure of Oakes, the way that Oakes structures the inquiry about the nature of a limit on a right, has set their court on the wrong course, and it's conducting the inquiry about limits in the wrong way. And one of the most simple points we make in the paper is that the way the court's done this is that it's often talking about infringing rights and presuming and conflating that the limitations on rights are the same things as infringing rights. And so then the whole inquiry about the government having a good reason to infringe rights for purposes that are rationally connected, a law that's rationally connected to that purpose, for minimally impairing in a minimally impairing way that is overall having the positive benefits outweighing the deleterious deleterious aspects, right? That whole inquiry is about the government justifying an infringement on rights and the court giving that the okay or not. And we think that that's a kind of problematic or objectionable kind of utilitarian way of framing the inquiry about the rights there. And it gets away at one of our very simple points. I said as a simple point, then I started going into the complicated part of it. But the simple point there that I think that we make is that it's getting away from the text. The text actually talks about limitations. So Section 1 of the Charter, it sets out the idea that the rights in the Charter will be subject to reasonable limits prescribed by law that can be demonstrably justified in a free and democratic society. Well, it doesn't speak about reasonable infringements. It speaks about reasonable limits. And so the court's reading something in there that has arguably had a objectionable effect on the way the inquiry is conducted. And I think the voting rights cases really have highlighted this. So we can talk a bit about the Sauvé case and later the Frank case and the way that this is structured. But maybe Gerard wants to jump in here.
Yeah,
Yeah,
maybe we could have just Gerard jump in on this question. So Jeff raises this question about the distinction between limitations and infringements, and says a little bit about why that matters. Gerard, do you have anything to add to that? Because that is a core part of your paper and the argument that you make there.
Yeah, I think that has pedagogical value, but I think it has some practical value as well. From pedagogical perspective, and in terms of the law's educative or hortatory role, it's a little problematic to say that the government can justly infringe your rights. Like if you look at instruments around the world, that tends to be language used for times of emergencies, whereas rights can be limited much more frequently, respecting more general societal interests. More generally, this tends to, for practical reasons that are understandable, create, in many ways, two tiers of rights in the Charter, because there are many rights in the Charter: the right to unreasonable search, to be free from unreasonable search and seizure, the right not to be arbitrarily arrested or detained, the right to be not subject to cruel and unusual punishment, that have a limit in them based right into the right. So there is a higher onus on the challenger to prove the law is limited. And then, frankly, it becomes very difficult for the government to justify limits on any of those rights. Indeed, you would think that would only occur in some kind of emergency. Whereas there are many other rights in the Charter: the right to vote, the right to freedom of expression, the right to freedom of religion, where it's comparably quite easy to prove the right has been limited. And then the real work happens under Section 1. And I'm not sure that's really in the best interest of either rights. Jeff has, I think, some interesting work in political science about how that ends up working out in practice in kind of odd and puzzling ways. So that, I think, would be a real practical implication of it. The latter stages of the Oakes test, I would also suggest, ask the court to weigh some goods that frankly aren't commensurable. And that is where I think you can really ask, is this what the court really should be doing? How do you weigh in the Hutterian Brethren case the integrity of a provincial ID system against the right of the Hutterites to drive cars because they do not wish to have their photos taken as they believe it violates the commandment against making a graven image. How do you do that? Like, I'm not sure that's something a court really should be doing. And it's interesting that in cases prior to Oakes, there was a serious question that you can't use utilitarian reasons to justify limits on charter rights. And yet, arguably, that's what Oakes kind of does. It asks, are the benefits outweighed by the costs of this law? Which one I think is ethically questionable, and two is probably not very well suited for the judicial role.
So yeah, Gerard, you mentioned the final two steps of the Oakes test and the balancing of incommensurate things. And one of the words that we've been using here to describe, I think, those final steps of the test is utilitarianism. Jeff, could you maybe just spell out a little bit about what that word is in this context, and why is it so bad if the court is utilitarian? What's the big deal?
Well, if we were going to get really technical in philosophy, utilitarianism is a branch of consequentialism and there's different types. There's rule or act consequential, at rule or act utilitarianism. But basically, it's the political philosophy that looks to the consequences of actions as they produce utility, maximize good, right? And you can think of that as in a rule way, where there's rules generally we should follow that maximize the good for everybody overall, or act, that every act must be justified in relationship to lead to more utility. You can also think of utility in different ways. You could think of utility in a more just pleasure way, or you can think of it as something more substantive. But we don't want to get into all the philosophy. I think we're using it in a very shorthand way, and the court certainly doesn't get into the philosophy. The court's concern with utilitarianism is that utilitarianism, because it's about the justifying things in relationship to the consequences that different acts have, is often kind of characterized as an ethical way of thinking that is contrary to rights and doesn't have a big place for rights in it, right? Because it's not about who's got which right, it's about what produces the most, in the words of one of my Russian ethics professors, more happy for everyone, so if we have that, if we have a utilitarian style thinking, rights aren't necessarily playing a big role. And what the court did, I think it was fun for Gerard and I to see that in some of the early cases where the court's poking around and figuring out how it's going to think about reasonable limits under Section 1, so pre-Oakes cases. And in one of them, the court makes this comment in Singh, I think, where the court says, well, we don't want to do utilitarian reasoning. We don't want to think about rights in this way that's just weighing the maximum good, where rights aren't going to play a big role. We're just making a utility call about what's the best outcome here, right? For the maximum number of people, the greatest good for the greatest number, sort of thing. That way of thinking is kind of, the court has this basic philosophical sense that that's inimical to the very spirit of thinking about rights as limits on what the government can do, regardless of how much happiness it leads to for the maximum number of people, right? Or that there's at least some way of rights are a limiting factor where it's thinking about rights should not just be pure utilitarian calculus. And I think Gerard's right that what we end up getting in Oakes is a turn towards something that seems fairly utilitarian, especially in that last step, right? The last step just seems hard to characterize as anything other than having a kind of utilitarian, well, how much good versus bad are we getting out of this?
Yeah. And I think that leads us really nicely to the bigger point here, the bigger question. We live in a world now where it's very obvious. You open the newspaper, you open up the internet. Many Canadians feel that the courts are increasingly taking over the domain of the legislatures, that the courts are increasingly being asked and are resolving major social policy questions. We can look at things like assisted dying. We can look at things like prostitution. These are all things that the courts have taken to resolving under the Charter. Would you, and I'll put this question to both of you, what parts of the Oakes test most contribute to that phenomenon? Is it the balancing at the end? Is that the worst culprit? What are the sorts of things that really do contribute to making the Oakes test a big part of this trend of the courts taking over issues of social policy?
I would actually say it's the minimal impairment test. The last part about balancing salutary benefits and deleterious effects, we critique it in theory, and we are not new to do that. Peter Hogg, probably Canada's leading constitutional scholar, also had grave reservations about that last stage of the Oakes test. However, the fact is that rarely makes a difference. I'll incidentally add that one of the cases it did make a difference was a decision from 2001 that in part declared Canada's child pornography laws unconstitutional for not having any artistic exceptions to them. But I think the real problem is in the minimal impairment test, because it's often easy for a government a court, Monday morning quarterbacking, to imagining what it views as a less rights infringing way to achieve an objective. And look, I don't want to say there's nothing to that. If a government can achieve its objective in a way that limits rights less frequently, that's probably, other things being equal, a good thing. However, I query the court's competence to assess this, especially given that there are messy trade-offs in legislating how you implement a policy. Sometimes a critique a court will say is, well, the policy doesn't have any exceptions to it. Well, there are implementation costs to having exceptions to general rules. Or will the law achieve the government's objective to the same extent? You occasionally will see the court saying, well, it might not achieve it to the same extent, but it's clearly would achieve it to a significant extent. Well, that's kind of the role of the elected representatives of the people to determine that, in my view anyways. So I'm concerned that and I don't want to overstate the problem here. I think a lot of the problems with courts taking over rules of public policy really concern the interpretation of rights themselves, particularly with respect to Section 7 of the Charter. I think that has had more mischief than Section 1 has had, but Section 1 can certainly play a role in this regard.
And I would say we make the case that the way Section 1 has set up the inquiry about limits on rights does contribute to some of these other problems we see systematically, where the court emphasizes less talking about, less interpretive concern for the text of the Charter and the nature of the rights in question specified by the text, because it tends to just let the inquiry, the first stage of the inquiry about the rights infringement, it tends to be fairly, I would say, quick to find a rights infringement in a way that makes the inquiry focus more on these parts about whether or not the infringement is justified, rather than talking about the nature of the right as it relates to the end the government has in mind. So even when Gerard was talking about the minimal impairment thing, it's also that when the court's conducting the minimal impairment inquiry, it's not asking, okay, do they have their own conception of the right here as it relates to this end that makes it less minimally impairing or not? They've just assumed that it's violating the right. And so their whole inquiry is oriented towards, does this exception violate it less or this exception violate less? But there could be arguments on the other side saying, and counsel should maybe be able to make arguments like, this is not minimally impairing because we don't think it's violating the right, because it's this part of this thing is protecting this right in this way. It's protecting the right in this way, this alternative conception. But the way the legal argument's structured encourages the lawyers for the Crown even to say, no, at that stage, we would admit that we violated the right, and here's why it's not violating as much as you think. But that's not the way that inquiry necessarily needs to go, right?
Well, on that note, so I've asked about Oakes kind of taking over this domain of the legislatures. Let's get on the table really clearly, and I'll put this question to maybe both of you. How does your proposal in your paper solve this problem or attempt to solve this problem? It's a big problem, so it may not be that the paper solves it, but how do you make a move in that direction in the paper?
Well, first, I think we have to be realistic. Oakes is very much part of the Canadian legal culture. We are not advocating for it being overturned. It would be very disruptive. And we also think that some degree of structure to Section 1 analysis is necessary, which is why I think we use the language of renovation rather than overruling. Not saying there's no Supreme Court decisions that should be overruled, but this is not the first one I would put in mind. So with that preamble, I would suggest that first we should actually be consistent in our language that Oakes justifies limits. It doesn't justify infringements. This, in our view, would have practical and hortatorial value or pedagogical value, as we discussed. It goes back to the test, and it prevents absurd situations where you have to say, like, a 1-year-old Canadian citizen had her right to vote violated, but it was justified. No, there is a limit on the right to vote that clearly falls within the ambit of. We also would suggest that at the minimum impairment test in particular, courts should accept the government's policy objective, with very rare exceptions. There might be sometimes a government wants to violate a right for no good reason at all, and ask whether or not its proposed alternative would actually advance the government's policy objective to the same extent. And a court should be humble about its own limitations in assessing that and its comparatively narrow ability to consider these issues of public policy when you compare them to the legislature.
Jeff, do you have anything to add to that in terms of how the paper works towards trying to peel back this trend of courts taking over the domain of legislation?
Yeah, our third recommendation is also that the courts should try to cut down on the last step of the overall Oakes inquiry, where they're just doing the deleterious versus salutary effects of the law, and rather it's insofar as they can recharacterize that step as a matter of just explaining how the law protects or does not protect rights as part of its proportionality. Much of the work that's supposed to go into that section should already be done, and it should be less of this, or maybe to save it just very much for emergencies, like Gerard said. But in any case, that is not the prong of Oakes that does the most mischief in our view. But we think that cutting down on that could at least do some good as well. And I should just say, we overall take our cues from the dissent in a case called Frank in Canada, which was about non-resident voting rights, where the majority held that restrictions in the Canada Elections Act on non-resident voting were unjustifiable infringements under Section 1 using the Oakes test. And the dissent was very vigorous by Justices Cote and Brown, as he then was. And the dissent made a lot of these points about limits very very carefully and very forcefully, drawing on some of the excellent scholarship about this, like scholarship by Professor Gregoire Weber and now Justice Bradley Miller on the Ontario Court of Appeal. And what the dissent said was, think about how, I'm very much paraphrasing it, think about what a problem it is that we've set up the idea that parliamentary restrictions on non-resident voting are infringements. That this whole way of thinking about this characterizes other parts of the Westminster system, restrictions like you vote in a constituency, that are just part and parcel of what makes a Westminster electoral system electoral, as infringements that are justified on this expansive right to vote. Surely this whole way of approaching this is mistaken. It's allowed for a more expansive conception of the right that becomes a matter of more arbitrary judicial judgments about what's a justifiable infringement and what's not, that ignores the contours and nature and scope of the right as it relates to this complicated system that it's part of. The right to vote is part of the Westminster electoral system, right? And so you could argue that restrictions on non-resident voting are not an essential part, not essential enough a part of that. So they are unjustifiable restrictions on the right to vote. But that's at least taking the argument, has to take seriously the argument that they may not just be an infringement. Then we shouldn't just propose the whole inquiry as that they are prima facie infringements, but rather they might also be just part and parcel of having a Westminster system where you live in a constituency and vote for a member of parliament, right? And they took that was not only a reasonable view, but a quite reasonable view. And that part of the problem with their colleagues' way of approaching the right to vote in the majority opinion was that they had just assumed that all of these restrictions were infringements. And the majority kind of says, sort of dismisses this point as just semantic. But I think that the dissent does a good job of saying this is not just semantic. This is about the whole structure of our inquiry.
Yeah, so very interesting stuff. And I mean, as you can imagine, as you know, because Oakes is so embedded in our constitutional culture, there are certainly counter arguments and counter positions to the ones you just advanced. And so let's give those a little bit of credence and talk about that a little bit. How I think the people that are opposed to your position would push back by worrying about giving more leeway, more deference to the legislatures and peeling back the role of courts. And I think the worry here is that if we give more leeway to legislatures to construct the scope of rights, we might end up giving majorities power over minority rights. And one of the things the charter was set up to do was to prevent that sort of thing from happening. So how would you respond to that criticism? And maybe we'll go to Gerard for that. And if Jeff, you have anything to add, I'd be interested in hearing it too.
Yeah, I mean, it's first and foremost, it's not completely without merit. I will just bite that bullet. There is something to that. And when you look at least the first Sauvé case, this is, again, is the case of the right to vote, there is a very crude legislative decision that, I mean, you could say was a legislative decision, but concerned prisoners, clearly not a popular group. And a lot of the Section 12 case law, again, concerns penalties for those who are accused of crimes, not the popular group in the world, to put it mildly. And so it is, to some significant extent, the duty of the court to uphold what the charter was meant to do, which is to uphold minority rights. When, however, it's one thing to be talking about, say, the realm of criminal procedure, or even very clear free speech cases or discrimination cases. But when you are talking about much more complicated decisions, such as how we construct our electoral system, or how we have a comprehensive advertising scheme related to elections, or I mean, Section 7 doesn't usually go to Section 1 case law for a reason we can talk about, but where we're in some really, what some would say, micromanaging of public policy in the realm of, say, bike lanes. This is far beyond what the Charter's original conception was meant to do. Moreover, a lot of our Charter rights are not instances of the state engaged against a singular antagonist. They are much more philosophical. They will be subject to reasonable disagreement as to their interpretation. And very often, the court is not in a better situation than the legislature to determine that. So I'm concerned that our courts might actually be less respected when we really need them, if we ask them essentially to do too much that's traditionally the purview of the legislature.
Jeff, do you have anything to add to that?
Oh, yeah. I'm going to add a point that might make Gerard slightly uncomfortable, which is that, and I was really worried, which is just that there's this picture people have of the tyranny of the majority and courts as this savior. And for a political scientist, it's a fantasy, because courts do not save minorities in the long haul if there's enough majoritarian pressure to take down a minority. And that's precisely because political majorities over time end up appointing courts and influencing them, and public opinion influences courts. And so just if you talk to comparative political scientists about what happens in authoritarian states that transition from democracies, you'll find that courts are very rarely a reliable institutional mechanism for resisting a tyranny of the majority. But they and actually, one of my colleagues has really fascinating work where he shows that even in authoritarian contexts, judicial review sometimes and judicial independence will be tolerated because it's an insurance program for the authoritarian regime, insofar as there's any competition for leadership of the authoritarian regime. If you're out, you have at least some kind of legal system that might save you a little bit. But I would just say that, taking that in the big picture, that if we ever deal with a truly tyrannical majority, the courts are not necessarily going to save us. In fact, judicial power often is used in ways that gets political actors off the hook and lets them not deal with certain controversial issues that they might rather not deal with. And so if we care about accountability, we care about holding our electoral officials accountable for different kinds of controversial rights issues, and we care about those rights issues, we sometimes do not want the courts being the only taking over, because it lets our elected officials off the hook. And I think that way in which judicial power is actually often empowered by the way political actors have a preference for not dealing with some of these questions is something that gets a bit missed. And no offense to you two, but in the law school classrooms, about courts are this just completely apolitical break on the other branches. I mean, no political scientist believes that. So this is like maybe one or two, but none from North American top tier departments think that. I just think that the people need to hear that more, and that when we talk about this, it's not just the courts are this absolutely independent thing, and the legislatures this big mean threat to rights. The courts are often where they're being the most activist. It's often the case that sometimes the case that they are doing this for specific political dynamics are enabling that, and those can be quite complicated and interesting. Also, not as simple as legislatures just let courts do whatever they want to get off the hook. But sometimes when we see what we call judicial activism, it's because our system's developed in a way where legislatures have gotten used to and profit from courts being the ones dealing with these situations. And it's not necessarily the courts holding their feet to the fire. That's not to say that there's not counter-majoritarian judicial review. There is, and it can counter the tyranny of the majority in some cases. And I'm just saying that the big stakes claim, it's a very strong claim to say that, well, the courts are this saviors for us all from majoritarian tyranny, and I just think that's false.
I am going to briefly add a couple of thoughts to that. I certainly agree that in a sufficiently tyrannical society, counter-majoritarian judicial review will not save us, and I do think there is some instances, and I would say assisted suicide is an example of this, where the legislature has been quite happy to let the court make policy decisions that it thought were too politically toxic to take, in ways that I would suggest were probably not in the best interest of the policy, the judiciary, or the legislature. Having said that, as Jeff did acknowledge, the counter-majoritarian judicial review has a role. I think it has a particularly important role when it comes to review of executive or administrative power, where the elected representatives, the people through the legislature, have given power to other entities in the state apparatus to make sure that they actually stay within their lanes. Judicial review can be quite effective and important in that regard.
Maybe a follow-up question on that to both of you. It strikes me that when we have these debates, oftentimes we get, in this contest between legislatures and courts, we get caricatures of each. So I think, Jeff, there is this almost caricature of courts as being, they're the saviors in case they're putting the brakes on the legislative branch. And sometimes we get a caricature of legislatures that they are, this is the hall of democracy, free and open debate, that abstracts away from some of the limitations of legislatures, omnibus bills, closure of time, things that prevent debate from happening. Do you think that this discussion on the Oakes test would be improved if we just talk more realistically about these institutions? And is that even in our current culture and legal culture, is that even a possibility? Is that even a live possibility? And maybe we'll go with
Let me just say one thing about that, which is I find it I think it really speaks to this point you're making, that when the notwithstanding clause is used, the alarm bells go off from everybody, and we hear from the entire Canadian punditry class talks about the infringement of rights, the override of rights. But whenever a case comes up where the Section 1 is used to uphold what the court calls an infringement of rights, we never hear any alarm bells, despite the court's own way of talking about this is talking about there having been an infringement of rights. It's just justified. It speaks to the fact that one institution, and sometimes those decisions seems very political, frankly, like what's going on, right? Or political if they strike it down as an unjustifiable infringement, right? But there's an asymmetrical skepticism where people are not skeptical enough about what happens in courts, and they are extremely skeptical about what happens in legislatures. And I don't think that they're wrong sometimes about the legislatures. I just think we should be applying our skepticism a bit more evenly. And Section 1, in a way, was intended to have us do that, to have us acknowledge the role for legislatures in determining some of these rights, and to direct the judiciary to acknowledge that. But it's kind of become the reverse. It's kind of become the Section 1 has enabled the courts to have more discretion ultimately. And I think that that's a problem.
Go ahead, Gerard, if you have something.
Okay, sorry. Sorry. Thank you. Just collecting my thoughts here. I realize there's a concern about idealizing either institution. I think, to be fair to those who are skeptical of Section 33 but not Section 1, they will sometimes enter. Coyne, for instance, has argued that Section 1 authorized reasonable limits and Section 33 authorizes unreasonable limits. I don't think that's the most charitable interpretation of Section 33 at all. Because there's going to be reasonable disagreement about what is a reasonable limit, nor does that respond to disputes over conceptualization of the right itself. Having said that, I think we need to be very careful not to idealize legislatures either. Jeremy Waldron, very well-regarded legal scholar at NYU, can sometimes, I think, have a little bit of an idealized view of legislatures. And so I think we need to take both institutions as they are, but I also think we ask, where do we ultimately want accountability in our system to lie, recognizing limitations of both institutions.
Right. Okay. Well, with that, let me move to kind of the concluding part of our discussion here and ask you this question about your paper now and the renovations you propose. Let's crystal ball and assume the courts accept your proposal. If they were to adopt it, what do you think would happen first? What would change first? Would outcomes of cases change? Would the way judges reason to those outcomes change, or would just the way we talk about rights change? And all of these would be big developments in our constitutional culture, but which do you see maybe occurring first, or which would be the most important to occur first?
I think the first and most important would just be how we talk about rights,
Yeah.
how we talk about how they are conceived. And I think that is a tremendous good in and of itself, because it returns us to first principles, and that will inevitably affect the results in particular cases.
And it may be that in some cases it actually results in less deference. Perhaps we're perfectly comfortable with, in some of these cases, it may be that having the limitation be talking more about the scope and nature of the right means there's just less room to talk about justifiably overriding it there. So it's actually more likely the court strikes something down. But it also may be the case that in some of the cases where the court's been more aggressive, talking in concern for the legislative role in specifying the right may force the court to be a bit more moderate in how and deferential to a legislative alternative articulation of a reasonable limit on rights in those contexts. Understanding the reasonable limit as being partly about the scope of the right as it relates to a specific kind of policy context, right? So maybe we get deference in some cases and less deference in others, and I think we're both comfortable with that. I was adding a bit of political science skepticism about courts to this because I knew Gerard wouldn't as much as me, so it's kind of my job here. I'm the bad cop. But I do take it that legislatures violate rights and that the courts have a role in sometimes acting in a counter-majoritarian or whatever you say, non-counter-majoritarian fashion. That's nevertheless in its reasoning protecting rights.
Yeah, I mean, with very few exceptions in our paper, do we take issue with the results in particular cases. Our concern is more with the reasoning process. And I think it's certainly plausible that in some cases less deference will follow. We're not arguing for a rights-based analysis. We obviously are building on trends that we think are concerning. But we're not trying to oust judicial review in this paper. That is not practical, it's not going to happen, and it's probably not desirable.
Okay. Well, I think on that note, I want to thank you both, Gerard and Jeff, for joining us today on the podcast to talk about your forthcoming paper. It's this tells us a lot about the health of our democratic institutions and the relationship between legislatures and courts, and it's a subject we're all interested in, and it's more topical now than ever. So, thank you both for joining us today. If you listened to this conversation and you really enjoyed it, do us the favor of liking, subscribing, and sharing it with others that might be interested. That's all for today. For the Macdonald-Laurier Institute, I'm Mark Mancini, and thank you for your time and for listening today.